Millions of people are currently using general-purpose language models for mental health support, often without any connection to a clinical provider. This behavior creates a specific legal byproduct. The internal systems built to monitor user safety generate a searchable record that attorneys can access in court. Integrating a human clinician into an AI product is more than a marketing choice. It is an architectural decision that dictates who can legally view the resulting data. Today, AI health products are following two distinct operational paths. Path A relies on unsupervised large language models, while Path B integrates a licensed clinician directly into the interaction. Conversations on Path A are classified as corporate records. This status makes them subject to subpoenas and discovery in both civil and state investigations. Path B changes the classification. When a licensed professional is part of the loop, the interaction is redefined as a patient encounter. The difference between a technology company and a healthcare provider isn't defined by the sophistication of the code, but by where that data legally resides. In a standard chatbot interaction, the log is an unprotected corporate asset. Because it isn't a medical record, it is subject to the same discovery rules as a standard email or a storage bucket. While federal legislation on AI remains stalled, state attorneys general are using their existing consumer protection authority to act. They don't need new laws to investigate claims of deceptive marketing or user harm. This is the Florida State Capitol, where Attorney General James Youthmyer launched a formal investigation into OpenAI using state subpoena power. The investigation cites the shooting at Florida State University, where the suspect allegedly used AI to research the attack. Those prompts have now moved from a private server to a central piece of a state investigation. Subpoenas at the state level can extract more than just chat logs. They can compel the production of internal safety memos, testing results, and logs detailing how the company handled sensitive queries. This process forces internal corporate decisions into the public record, allowing legislators to see exactly how these models were tested before they reached the market. As state-level enforcement scales up, private data that companies previously considered proprietary is being transformed into public evidence. The legal weight of these records is now being tested in a wrongful death lawsuit against Google involving its Gemini Live platform. According to the complaint, as a user experienced a psychiatric crisis, his interactions triggered the platform's internal safety monitoring systems. The system generated 38 sensitive query flags over 6 weeks, yet records show 0 human interventions. This creates a direct link between what a company logs and what plaintiffs discover. The 38-to-0 ratio is Exhibit A. Each flag acts as a time-stamped record showing that the company's own systems recognized a user was in distress. The legal argument here is that the injury wasn't caused by a technical glitch, but by a product designed to prioritize engagement over safety protocols. When a system logs a crisis but provides no way for a human to intervene, it provides a roadmap that attorneys can use to establish a failure in the duty of care. Features intended to make an AI safer often become the primary evidence of negligence when they operate without human oversight. These subpoena risks have led some operators to adopt a different data pipeline that addresses the discoverability problem. The method involves integrating licensed clinician oversight directly into the loop where data is processed. When a prompt is routed through a licensed professional, it moves from a raw text file into a different legal category. That log is now classified as a patient encounter, covered immediately by HIPAA and therapist-patient privilege. This classification brings the data under state patient confidentiality statutes, which are much stricter than general consumer data laws. By operating within a clinical framework, companies can shield these interactions from standard civil discovery and the reach of state consumer protection subpoenas. The presence of the clinician redefines the interaction, moving the record from the category of corporate asset to protected medical information. Some states have responded to these safety concerns by trying to ban AI mental health tools entirely. However, prohibition can be counterproductive. It often pushes users away from specialized tools and toward general-purpose chatbots that have no health-specific safety features. Utah has taken a different approach by establishing a safe harbor framework that sets specific requirements for AI health tools. The Utah model requires 4 pillars: pre-deployment testing, crisis escalation protocols, clinical oversight, and continuous monitoring. To stay within this safe harbor, companies must maintain an auditable record of their safety efforts, proving that they are following their own protocols. This legislation mandates that a human review the interaction whenever certain safety thresholds are met. These laws also set time limits for human review, ensuring that a flagged crisis receives a professional disposition within a defined window. Regulation is beginning to shift from simple bans toward requirements for engineered, auditable safety compliance. As the peer-reviewed evidence for AI therapy remains a subject of debate, the legal system is stepping in to address the safety gaps. The pattern is becoming clear. When a company logs safety flags without human oversight, those logs frequently become central to subpoenas and civil discovery. The alternative is an architecture where mandated human review creates a protected health record, keeping the data within a recognized regulatory safe harbor. Over the next few years, the market will likely split based on how well companies can protect the records they generate. For those building and investing in these tools, survival depends on a fundamental distinction. You cannot treat health data the same way you treat standard consumer software data. The choice is binary. Companies can build an architecture that keeps records inside a protected health system, or they can let them open to the next state subpoena.